Working session for the Consolidated Commission on Utilities, dealing specifically with the proposed rules for the CCU. And the hour I have on my clock is 3:36. For the record, those present are myself, Commissioner Chaco, Commissioner Sanchez, Commissioner Judy Gutherds, and Commissioner Santos is on his way. He's running late, but he'll catch up when he gets here. Now, Commissioners, just as a wrap-up to try and bring us to where we are, I think we've settled all the different issues in the CCU rules. The only portion that we have yet to go through is the proposal on evaluations and how we deal with the appointment, evaluation, and dismissal of our employees. The question is in executive session or not in executive session. Would the commission like to have the legal counsel give his opinion? Might as well? Sure. Okay, Vince, the floor is yours.
You mean as far as whether evaluation?
Yes, your opinion.
Okay, so my opinion as far as the evaluation, not including the jams at this point.
Okay, you tell us why. Go ahead.
Well, because
You want to read it? You can.
the GM.
Their evaluation. That's all public. Because
The appointment of the general manager, is that in part of that law too, or is that law specific only to evaluations?
When it comes to the appointment of the GM?
Yeah, the part you just opined on in terms of the GMs, that they have to, there's an evaluation. I think the way I read it is within 6 months after they're evaluated, and every year after that they have to be evaluated, and then we have to put it in the newspaper, and we also have to tell why. But does it address the appointment of the GM or the dismissal of the GM?
that particular statute is talking, just talking about evaluations post-appointment. So you got 6 months after the appointment, and then you got to do your evaluation. And then every 12 months after that is when you do another evaluation of the GM. So it's not, we're not talking about appointments in that particular statute.
So, in your opinion, when you talk about the others, you talk about the appointment and the dismissal portion, would that still be, in your opinion, under executive session?
Yeah, when it comes to the other employees,
No, for the GMs.
no, okay, I think you're saying, you're asking me is if it's going to be an executive session this fall.
For the GMs or open session, even for the appointment part.
Right, I think it should be an open, at least as far as the evaluations. I don't,
Yeah.
when it comes to the appointment of it, I think, I haven't looked at that part as far as the actual appointment.
Yeah, that just can't occur to me.
So I haven't looked at that. Sure.
Commissioner, let's talk about this. Go ahead, Commissioner.
I mean, related to this
Sanchez.
topic.
Sure,
I mean,
sure.
I haven't reviewed the law in a while, but are you saying you're not sure whether even the appointment of the general manager must be done in open session? Seems to me you have to appoint them in open session.
What I'm
How
saying-
could you not appoint them in open
Okay.
session?
What I'm saying is I haven't researched that portion of the law. All I have is all I was asked was evaluations after they've been appointed, so.
Okay, so I mean.
So I haven't looked at it, so.
So at least my view is, it doesn't make sense to me as that the intent of the legislature is that you can make the GM's evaluation public, but you can't make the fact that you're hiring him or appointing him public. I mean, it seems,
No, I
it
think,
seems you have to, the body has to act, whether it's an acting general manager or the full-time general manager or whatever. We can hire 7 people, is my understanding. I'm not aware, and are you aware of any law that says you can hire any of those 7 people not in an open session?
No.
Correct. So, I mean, so it seems to me the appointment of the general manager must be done in open session. The pay of the general manager must be set in open session. And then, correct me if I'm wrong, your latest opinion says there's another law that says within 6 months of hiring, appointment of a general manager,
And annually.
they must be reviewed, and thereafter, every 12 months, there must be a review. And those reviews must be made public, right? So that's a clear exception to the interpretation and the letter of the open government law, that at least when it comes to the general manager, their review must be periodic, and it must be released to the public. Right?
That's for all agency heads.
Correct, of the general manager, right? And I just want to make sure, I believe, is it your, and please confirm, and your opinion also says that establishing any pay level for, I'll just limit it to the general manager right now, that also must be done in an open public session.
Yes, it has to be done.
And then the related question is, the other 6 people we hire, must their hiring appointment be done in an open session of the body? Also, for the
What is
other
your
6.
opinion?
The other 6.
Well, I think I put down that it's going to be done in the executive session to determine the evaluations of.
Right, but my question was the not the evaluation, so I'm choosing my words carefully because your opinion is careful. The appointment or hiring of the other 6 employees that serve at our pleasure, which you cited, their appointment or hiring must be done in an open session. We can't hire them quietly in executive session and not tell anybody.
No,
I would tend to agree with that. I mean,
Right.
what it is probably in the executive session, you're going to be looking at the different people that are involved. One of the reasons you want to keep it confidential is maybe other people don't want.
Yep, I'm all
stuff.
for that, I'm all for that.
But as far as-
But once you've decided, once you've evaluated in executive session the candidates for these 6 positions that we hire directly and who serve at our pleasure, to actually hire them, you must come out of executive session and perform the actual hiring in a duly advertised, properly advertised, open session. There can be no secret hiring of any of the 7 people that work for us.
Yes, I agree.
Okay, just
it's
making
always
sure.
been like that.
Well, just again, because we have counsel, I just want to make,
Okay.
make sure counsel is, I've always agreed with you on that, but we took, and I appreciate your suggestion, let's get counsel in here so we'll be clear. And I want counsel, the chair has allowed him to establish on the record his initial thinking. And I just wanted to ask him, as we review his opinion, as it relates to all 7 of the people we hire / appoint, I'm using those words interchangeably, right? The specific hiring or appointment of them, no mention of pay, just the act of hiring them, those must always be done in an open session, duly, in compliance with the Open Government Act.
I believe so.
But the discussion to get to the point of deciding on a candidate, that is also an open session, or does that occur in the executive session?
I'm thinking this probably should be in the executive session because
part of the
you're talking
evaluation.
about.
Okay, now, for just a minute, I would like to go back to our recent past, where we hired a CFO for Guam Waterworks. And exactly what we did was, we did the interviews and everything in executive session. We determined that we selected a candidate, and we determined that the candidate, I would inform the candidate, but we went into open session to talk about a price and a contract, and we said that the chair was empowered to make an offer to the candidate, and this is the final process where you go to the final candidate and say, do you accept this amount of pay and this contract? That's what we did. And when the candidate said yes,
Then we had one more process.
then we came
Then
back
we
to
actually hired-
then we actually hired them, yes. So
So
with
there's
that,
actually one more step.
so with that in mind, I agree. That's the way it works. In executive session, we did the interviews and all of that background work, And in the executive session, we selected a prospective candidate. We didn't hire yet. We said, this is our candidate. Then we went into open session to discuss what would we offer this candidate and how much would we pay this candidate. And then the chair was empowered to go back to the candidate and make the offer now for employment. And when the candidate says yes, then in open session, we hired the candidate. Okay? So I'm with you on that.
No disagreement on that.
I'm with you on that. So my question, see, is when it comes to hiring the GM, in looking at the law, it says evaluations will be in public. I don't have a problem with that. But in the law, in that section that you found, I didn't see anything that said that the interviews and all that is done in open session. So would we follow the same thing where we would conduct interviews in executive session for a prospective candidate, not hiring, and then go through exactly what we did with the CFO for GWA. And then once we had a candidate that we all thought would be the best fit, then we would go into open session and discuss what we would offer this candidate, the money and everything, and then empower the chair to make the offer to the candidate. And if the candidate accepted, then we went into open session to actually hire the candidate. And the only thing is, in my opinion, I looked at your latest updated opinion, it says that, but this law says for agency heads, the general managers, then
Every 6 months.
within 6 months, there must be evaluation, and that evaluation is done specifically in open session, and that evaluation must be posted, and you must say why you're keeping the person, and every 12 months it's done, and anytime you want to change the money, you do that, that's all rolled into the same thing. So that's what I hear.
May I make a comment?
Okay, wait. Okay, after, I'll let Judy
Okay.
talk first. Go ahead, Judy.
If you look at the material I gave you from DOE, all the news stories, that's the process. But there's one difference. The DOE board, they have a committee that evaluates it's just a superintendent. Because the deputy superintendents are hired by the superintendent. They serve at the pleasure of the superintendent. So the superintendent's evaluated first by the committee using their criteria, and they have a rating scale of 1 to 5. And so after they do the evaluation and then they use their rating scale, then they come up with a cumulative number. And then they provide the results, the committee, to the full board. And then the full board announces the results and explains the reasons for whatever it was.
Yes.
So I've seen situations where the superintendents, since this law passed, and every 6 months they get an evaluation of a 4. In one case it was a 3. That person's not there anymore. And then a 5, so the variations. And they have a press conference and they release the results.
Specifically with the GMs, I'm on board with that.
That's the law.
Now, because evaluation and leading to termination would also be in public, I'm just asking a question, that would be in public for the GM? Okay. Commissioner Top.
So your questions, Mr. Chair, the questions that you have though are currently in the executive session language, right? So, which is part of the rules.
Yes.
And it reads as, the CCU is not prohibited from holding executive sessions with the Attorney General, Chief of Police, or the respective designated representatives of each on matter which poses a threat to the public health, safety, or welfare, or from holding executive sessions during a regular or special meeting to consider the appointment, employment, or dismissal. So in that portion of the GCA, it's clear that you
Yes.
can hold executive sessions for the appointment, employment or dismissal, right?
Okay, okay.
So does that answer your question?
Yes.
That's
Yes.
okay.
So,
So I think
I-
what Vince was asked to opine on is just the review, the evaluation side of it, right?
And that's what I'm saying, specifically for the general managers, just the general managers.
Well-
No, I'm just saying, the evaluations are very clear here.
Right.
Because there's a specific law,
It's a specific law for them.
specific to the agency head.
Yeah.
So, I mean, it's crystal clear to me now. Okay, so I'm fine with that. Now, moving on, and just for the sake of clarity and accuracy, it's not just the CFOs and the 2 attorneys and the board secretary, it's also the AGMO, right?
No, it's just with subject, correct me if I'm wrong, the GM appoints subject to our concurrence, basically.
Okay,
Did I understand that right?
yes.
So it's not direct. In fact, I mean, we can say, no, we don't like the person, but we're not the ones evaluating, we're not the ones picking the person in the first place. We're not the ones reviewing it. GM says, I would like Mr. Cruz to be my AGMO or Ms. Santos to be my AGMO, and we have the power to say no or yes. I believe that is the only power we have.
Okay, my question is, in what venue does that discussion go over?
In an open advertised meeting of the commission, subject to
So
open government.
you're saying, okay, no, wait, I just want to follow this through, because I want to make sure we don't forget the AGMO. So could we just look at that for just a minute? So following your train of thought, you're saying that when the general manager decides to hire when the general manager
So here,
decide-
of GPA wants
of
to hire
GPA
the
wants to
AGMO.
hire the AGMO of GPA,
Right.
before he completes the hire, he comes to us in an open session and says, I decided to hire so-and-so, and in the open session, we give our concurrence. That's what you're saying, right, Vince?
But
But it could happen another way, too. I wanted to ask counsel.
Ask counsel,
All right.
ask counsel.
So when I fully agree with the chairman's description of something where the GM of GPA wishes to hire an AGMO and wants to hire Mr. Rettenbaum as AGMO, right? And there's 2 options. The body can choose to act and say yay or nay, or the body could choose not to act, which in effect is a tacit yes, right? We haven't said no, right? We just didn't take action. So in other words, we have the right to take action on it, but we are not required to take action on it. Whereas to hire a GM or the other 6 positions that we do have to hire, that takes a direct, there can't be a tacit hiring of the other 7 people that report directly to the GM, where the public is not made aware in a public session that so-and-so has been hired as GM, so-and-so has been hired as executive board secretary, so-and-so has been hired as CFO for GWA, CFO for GPA, counsel for GPA, counsel for GWA. There's 7, correct me if I'm wrong, right? There's 7 positions that we are required by law to hire, and all hirings must be done in an open session. But in the case of the AGMOs, is the ratification required in open session? It seems to me, if you wanted to fire them, if you didn't want to accept the GM's recommendation for the AGMO, you would do that in an open session, right? You have to, because to me, our actions only count when they're done in open session. Nothing counts in any other session. This is where the rubber hits the road, right? It's like in the legislature, you can talk about whatever you want at Kings or in committee.
But
It's on the floor where the action takes place. So our action of hiring any of these 7 people must be done in open. And then for the indirect hiring that the chairman is asking about, the AGMO, where we are given an opportunity to participate, we don't have to take that opportunity.
Well, I think that it says, general manager, they set up the board.
So does that require, so in your opinion, that requires an over action? We would have to put it on the board? Okay, that's okay. I mean, I want to get to
Okay,
the-
but here's a question.
Right, okay, so
So-
I'm with you there. So it does take, whether we accept the general manager's for AGMO.
General manager to hire the admins. And the general manager presents his recommendation or her recommendation to the CCU for concurrence. What would happen if the CCU did not concur? Could the selection of the
Agno?
general manager still proceed without our yes concurrence? No. So it's actually consent.
Of the GM, but not, you were talking about the AGMO.
No, admins. I'm talking about the admins.
What?
Remember the admins? The
No,
general
we're not-
manager.
We don't have a role on the AGMAs. We only have the role on the general manager.
That's what I'm saying. The general
I didn't
manager has made the
understand that.
decision who
Understand
he
it now.
wants to hire as his admin.
AGMA or AGMO?
Isn't it admin?
It's only AGMO GPA.
But it's part
That
of
we have a role.
the
We don't have I
opinion.
don't believe we have a role in any
And
other.
so therefore.
It's a
okay,
very,
just-
remember,
just-
GPA was created so long ago,
let's
right?
let's clarify.
That the board, now the CCU, and council, correct me if I got it wrong, my understanding is.
this for operating?
Since, right, the board did have a say over the AGMO appointed,
Yeah, that's what I'm
desired by the GM.
Yeah, that's what I'm saying
But
now.
only the AGMO.
But
no
what-
AGMA, no,
Oh,
only the
admin,
AGMO.
okay. So what if the general manager presents to us his selection and we don't concur? Does the GM's selection still proceed, or is our concurrence required, a yes concurrence, for it to proceed? It does, right, yeah. So actually, it's board approval.
Okay, just for clarification, this discussion specifically relates to the AGMO. Now, we were more concerned about the evaluation,
Yes.
and therefore, the evaluation is not done by us.
No, it's not.
The evaluation is done by the general manager, so that's not part of our current.
I mean, I'm not sure why we're talking about the AGMO at all.
No.
Other
I
than
think
to know that we should be taking a affirmative action one way or the other.
Yeah,
on
no.
all- On all AGMO appointees of the
Right.
Guam Power Authority.
Right.
Or, I'm sorry, the AGMO appointee. I
Right.
think we only have one.
it's just for clarity, that's all. But Commissioner Chaco is right, we are talking about evaluation specifically. Now, this is just discussion so that we can all understand what we're looking at. So therefore, and in the AGMO position, it says that if there's going to be a change in compensation, it is also with the approval of the board. That also should be done in open session.
Yes,
We're all on the same page.
yes.
Okay. Because actually, for all our employees, the others,
Has to be in open
it's
session.
all in open session too.
Pay
Okay.
has to be,
Yeah.
hiring and pay.
Are in open
And
session.
I guess by implication, firing is done in open session, right?
Well, it can be done, I think it can be done in the executive session.
Don't you have to vote to terminate the general manager? Wouldn't you have to vote? I don't know how you do that only in executive session for.
I think, okay.
I mean,
Just
to
a
me,
minute.
nothing's binding in executive session. I mean, that's
No,
the first
nothing is
rule.
binding, but can I
So
just ask?
How can you not fire, how can you fire someone in executive?
I don't think you can fire them in executive session, but can I ask the question for clarity? Vince, does the discussion though can the discussion, like the discussion to hire somebody, occur in the executive session? And then you come into the open session and you announce your decision. Or no, you make the decision in open session. And so therefore, we just need to make sure we're clear on this. I'm just trying to make sure we're all on the same page. If in executive session, we determine that we discuss the performance of this individual, we come out of executive session to make a decision on whether we want to keep this person or not. That's where the decision would be made, in open session.
What it specifically states that
Okay.
the end of the executive session to consider the appointment or dismissal.
Okay. In the executive session, the decision would
Action
be,
has to take.
take place in, yeah,
That's what
okay,
I think,
okay.
too.
I'm on board. See, we're all getting on board. Now, with regards to just the evaluation portion, based on your opinion, based on your review of the law, setting aside the two GMs, because that's very clear already for us.
Well, can we state that for the record? Your opinion is the general manager's evaluations must be made public within 6 months of hiring and annually
6
thereafter.
months. Is it
And
annually or
it's
6 months?
annually.
Six and 12. But they must be made public. Right,
Yes.
so your interpretation of that law is that the legislature and I forget how it was passed, the policymaking body, I don't know if it was overridden or passed and signed, but the process to make it law, that the law's intent was when it comes to the general manager's performance, or the phrase is what, evaluation, performance reviews, parentheses, evaluations, that's right in the law, right? The performance reviews, parentheses, evaluations of the general manager must be made public and published in a newspaper of general circulation, right? Basically to provide notice of the facts that the CCU announced, but it must be, so this issue, that there's been a debate at the commission level about whether evaluations should be made public or not, whether they should be required as a condition of employment. At least for the general manager, the law is clear, their evaluations are public.
That's right.
Okay, thank you.
Okay. So now, where we're at is, what is your opinion in terms of the evaluation? And then we can all ask questions. Go ahead.
The evaluation of the remaining
Of
employees?
the remaining
Yeah.
individuals.
So it's my position that because
Oh, okay.
No, no,
After, okay. Go ahead.
is that an evaluation is going into the personnel file. In fact, I found a case that specifically came on, was talking about that, and it was interesting that the case was authored by a person who eventually became the Supreme Court Justice. That would be Scalia. So that particular case said that evaluations are private. So if it is private, then the way I was looking at it is that it should be, an evaluation should be done in an executive session. And if you wanted to eventually give them a raise, I would have to be done in open. As far as talking about the evaluation, grading that would be an executive session, and that would be a private thing.
Okay. Commissioner Chalco, you had your hand up.
Okay, thank you, Mr. Chair. So, my question is in reference to whether or not potentially these other employees directly under the control of the CCU, such as the CFOs, the legal counsels, and the CCU secretary, can enter into an employment contract in which it is known at the time that their evaluations will be subject to open session meetings, and that their evaluations will be made public. And the rationale behind that is the same rationale that you had cited earlier regarding the legislature's passage of, I believe it was 5 GCA. Let's see, 5 GCA 43202. The basis, the intent of that law is the same thing we're trying to achieve with the other employees or appointees of the commission, which is to ensure that these people that we have entrusted with these positions are performing as they should, and that it should be made public, right? So that the ratepayers can know that their utilities are being run properly in all of these executive positions, the GM, legal counsel side, the chief financial officer. So barring the fact that it's not codified like it is for the general managers of GPA and GWA, can we include that in their employment contract, that their evaluations will be subject to open session evaluations?
Before you answer, can I just have a point of clarification. If I heard, I want to make sure I heard you correctly, Commissioner Chalco. You said that the opinion is that the discussion on evaluations is in executive session. And you're saying, given that, then, but can you still ask in a contract the employee to waive that right? Is that the essence of what you're asking? I just want to make sure I understand the question.
Not necessarily waive that right. In the employment contract, it would be a stipulation of the employment, is that they're required to have their evaluations be done in public, in open session. So they're agreeing to that as a term of their employment.
Okay, no, but I want to make sure I understand what you said. I thought I heard you say that you understood his opinion to say that the evaluation properly belongs in executive session.
That's not what I said.
Okay, that's why I'm asking.
Yeah,
That's
so,
why I'm asking.
so no, that's not what I said.
That's not what you said. Okay, so you're saying, notwithstanding his opinion, then can
Mr. Mayor suggests that just let Commissioner Santiago ask
Okay.
counsel
Well,
instead of
I wanna
interpreting
make
it,
sure I
and let
understand the
counsel
question.
respond, right? I mean,
Yeah,
then we
okay.
can go back and forth over,
Okay.
well, okay,
Go
I got
ahead.
this. But I
Go ahead.
I never heard the response to
Okay,
Commissioner
no,
Santiago's-
I'm sorry. I
appreciate you
I
trying
just
to-
wanted to make sure I understood the question.
Yeah,
That's
so,
all.
so just to reiterate, right, we've already cited the existing statute that requires that our general managers of the utilities, their evaluations not only be held in open session, but that also are made public and are actually published, so that, all of Guam can see them, right? So I don't see a large difference between our general managers and our chief financial officers. They're responsible for a very focused scope of work in relation to the utilities financials. Legal counsel is also very focused on the legal matters of the utility. So I hold them to the same standards I would hold the general managers. And so the intent of the law that exists now to evaluate general managers in an open session and to make those evaluations public, to me, remains the same for all of these positions that the CCU is responsible for. And therefore, since it's not codified specifically to include CFOs and legal counsels, my question is, can we make it part of their terms of employment in their employment contract?
Well, the first part is the fact that it's not found in the code. There's like a presumption that if you specifically refer to something in a different portion and you say, well, this thing has to be done, and then you refrain from saying it on other things, then there's a presumption that maybe that's what they don't want. So there would be a distinction between the general managers and the other employees. So the other employees, so what I was saying is that I believe that they would have a right to privacy at this point.
Okay. And so my opinion is that I think I would agree with you in the sense that if the general managers were responsible for these other employees and were responsible for the employment as well, I would agree, because in those instances, right, the general managers would be evaluating those employees themselves. But they're under the CCU's direct employment contract, right? So that's why I asked the question, right? So maybe I can understand your point. Maybe they meant to exclude it, but you can also argue the point that maybe that exclusion was because that type of situation that we're currently under doesn't exist. Typically, the chief executive officer is responsible for everybody under him, right? In this case, with the CCU, we're actually responsible for those CFOs, right? We don't rely on the general manager for those evaluations. It's our responsibility. It's in statute, right? So therefore, I believe that the intent of this law really was for those employees that are under the control of the board, because it says the governing boards of the agencies, right? Is that maybe in this instance, right, at that point, it was only for those, the GMs, right, that the board would be specific to hire. But in our case, we have to hire the CFO, the legal counsels, and the secretary. So, that's the question is, okay, since we are responsible for that, and we can enter into an employment contract, is that legally feasible? Could we make that a term of their employment?
Okay, now as far as it being included in the employment contract, first of all, I would say that they have this right of privacy. So if you wanted to include that in the employment contract, to me, it would be considered a waiver of that right of some sort. And for it to be effective, the waiver's got to be very, very clear and all this other stuff. There's all kinds of things that you have to go through. And so, yeah, you can have them waive it. Then the question is, if there is a dispute later on, that's not going to prevent any, not going to say that it's impossible to litigate, and then it just might be inviting litigation later on. But I think you can waive it, and whether they're going to continue with their waiver, that's a different question. Whether they decide to change their mind on the waiver, they can always do that. And then, like you were saying, what can be done later on is, there's the door or whatever you want to do.
Commissioner Sanchez.
So you're, correct me if I'm wrong, you're saying if someone signs a contract in which they agree to waive any apparent right to having their evaluations private, if they sign a contract, they can come back later and renege on the contract?
They have it all the time. That's what they call it.
But they would have to fight that they were, but they would argue about,
Yes.
but then we'd be arguing contract law, like,
Yes.
did you sign this,
Well, I think
Mr.?
at the
And
very
yes, were you aware at the time that you signed that you were waiving it? And now you want to back out of your contract? At least that would be the logic of one side of the dispute.
Yeah, for whatever reason, they may challenge it and say, well, there's a thing about overreaching and all this other stuff. And they can
But
say,
you
well,
signed it.
I'm sorry?
But that person signed it.
Yes.
Okay.
But they might, one of the things they might say is, in defense, say, well, I had no choice. If I wanted to get this job, I signed it. That kind of stuff. I'm not saying it's going to work, but what I'm saying is that later on, it could cause problems later on.
So you're advising that there's a risk if we were to put this clause.
Yes.
There's no guarantee, okay.
I have no-
Wait, there's no guarantee that they can't sue you. Of course, there's no guarantee that anybody can't sue you when you sign a contract with them. You can sue even the day after the ink is dry on a contract. A party could sue the other party, correct? Right? I mean, there's nothing binding a contract between two parties doesn't bind either party from saying 1 second, 1 day, 1 year after the ink has dried on the signature, I wish to contest my contract. Right? So to me, you're saying kind of an overall, general awareness. We should be aware that any contract can be challenged. But, let me ask you a different opinion, but from your experience, in a situation where a contract has made it clear that you have waived your right, who would, let's take our case. If we put this in our contract with our 7 employees, and we said, as a condition of employment, you must waive your right, and that employee sued us, how would you defend us?
Well, first of all, I don't want to give an opinion as far as whether it would work at that point, because I'm not...
Well, I'm asking you different. How would you defend the CCU who put in a clause for Mr. Cruz to, as a condition of employment, you waive your right to privacy on your performance evaluations, and he signs it? How would you defend the CCU in that matter?
It depends on what their complaint is. Now, if they're saying it...
Well, let's say their complaint is I'm contesting the part where my performance evaluation is public.
So then you're
Just
saying...
that. Let's say that's the only basis he's suing, after he or she signed it.
So I assume you're saying that this contract is not enforceable, is what you're saying.
That would have to be the complaint from the person who signed the contract, right?
Yeah.
And their basis, let's assume their only basis is because I waived my right to the disclosure of my evaluations, I can sue that this contract is invalid, even though I waived it? How would you defend the CCU?
Well,
Well, let me hear. How would you defend the CCU?
it would depend on the situation. I don't know.
Well, I'm giving you a general one. This is a contract in
Well,
which...
what I would normally say is, okay, well, we have a contract, we have an agreement, and this is what it was, he signed it, so we stick with the contract, and that's what I would say.
Okay.
In general, but there's other things
I
that go on.
understand. But in your general understanding of the law, is that if we put in a clause and we were sued, our defense could be, I'm not saying it's the only one, could be that you signed a contract specifically waiving your right, and you're bound by that contract.
But on the other hand, what I'm saying is that they can also say that, if you were the employee, you can say that I had no choice, and so it wasn't a knowing waiver of...
What do you mean by knowing waiver? It's in the contract.
Well, it wasn't voluntarily done.
You signed, we didn't put a gun to your head to sign the contract.
Well, there's cases that say they have no choice, they're gonna.
Well, they have a choice not to sign the contract.
You know what, Commissioner, we're going through a hypothetical, so let's get back
Well,
to.
no, because his opinion, his opinion as of 9:37 said that, I'm reading here, my thought is an employee can waive his right to privacy, so he can, right?
Okay, well, that's his
And
what he
the-
stated.
And the question, I'll use his words, the question was, which I guess you're alluding to, the potential risk, right? Is that notwithstanding the employee waiving his right to privacy in a contract, the employee can reassert it, I guess being the right to privacy, right? Can reassert their right to privacy, even if they've signed a waiver of that right to privacy, right? So I'm just making sure I get your opinion. Sure. Correct, okay, all
Okay,
right.
Commissioner Guthrie.
Yeah, thank you very much. First of all, this is my thinking. Did a little research. From the very beginning, the contract would
Would be the,
meaning it could be challenged.
oh, okay.
Because including that provision in the contract is already contrary to law. That's my position.
Not
Number
according to
two,
opinion.
No,
Let her
it's not
finish,
consistent
Commissioner
with what
Sanchez.
the law says right now for the positions other than the general managers. Number two, it sounds to me that this would be a condition of employment. That you're saying that evaluating all the candidates for these positions, let's say the best candidate is not willing to support that provision in the contract, you would not hire them. That's another issue. That's another infirmity. Because that is in contradiction to the law. You're saying, I'm only going to hire you if you agree to this. I'm only going to hire you if you agree to this. If you don't agree to this, we're not going to hire you. Even if you were the best candidate that we rated for the position. So you're asking them to agree to something that's not consistent with the law. That's my position.
Which law, though? There's two laws that one says you can, one says you can't. So which law are you referring to?
Okay,
We can't use the general manager's
Why?
law.
But they're the executive in that position, right? So the CFO is the same in my
But the law
eyes.
doesn't say that,
okay,
Michael.
okay, so there's a
law
lawyer
doesn't say
here,
that.
just a minute. Let's let him give us his thought. If I understand you correctly, you're saying, hey, the legislature said the general manager, and these by comparison are also in the same boat, so we should move that way. You need to tell us what the law says.
What I said earlier is,
Okay,
and, hey, generally you can waive, waiver has to be good in my opinion.
Has to be what?
but,
I'm sorry, has
It
to be
has to
what?
be sufficient, otherwise it's not going to work. And
The waiver has to be sufficient?
it has to be.
What does that mean?
There's all kinds of reasons why waiver doesn't work. They very strictly enforce usually when it comes to waiver of rights.
Can you waive it as a condition of employment? In the private sector, you can.
this is.
Like waiving your rights to bear
I know, but in
arms.
the private sector, I've
Okay,
seen lots of
okay.
conditions, and if
Just-
you want the job, you decide, right?
Just a minute.
Short of breaking the law, right?
Commissioner
I just have
Sanchez.
one question. Is this really something we want to do for how we view our managers? Remember, I had that question before. It only works when it's good, but I don't see us here, if there's something bad about our managers, we all going to come out publicly and say it? Or we all going to run into the room and hide? I mean, that's my question, because that's the honest, fair question. When it comes down to evaluate, we're all rah, when it's good, but boy, when it's bad, I bet you some of us will run and hide. I'm just curious, what are we trying to accomplish here? Because I don't get it. I mean, we haven't done an evaluation in a while.
Commissioner
So
Chao.
I'm just
Okay,
curious, I mean, really, what's the end goal?
Commissioner Chao.
So just to respond to that, Commissioner Santos, absolutely. And if you take a look at the evaluation forms that are part of the rules right now, they're very objective. They're very clear measurements, right? So I think your concern is whether or not we're going to, if the question is, am I going to be the first commissioner that says, sorry, Mr. General Manager, but I rate you as a 1, the answer is absolutely. because that's what our voters expect from us, right? But these evaluation forms are very objective. They're saying, did you meet this goal? Did you meet this goal? And so we're not trying to throw anybody under the bus or make them look bad for their next job. They're very objective. They're not, my opinion of you is a 1. It says you were entrusted with meeting this metric and you did not meet that metric. And I think it's important from my perspective that I am the first one that says you didn't meet it. You know, we talked about it, we met, we planned, we agreed to meet this metric. You didn't meet it, you know, and if they come up with a explanation as to, hey, COVID-19 happened, all right, that's it's a force majeure issue, right? Okay, we understand you didn't meet it for those reasons, but I think it's important that we hold all of our managers to those key performance indicators. Now, I'm definitely not going to be the one that says, I don't like the way you talk to people, or I blah blah blah. I'm not gonna make subjective statements about the manager. I'm gonna focus strictly on this evaluation form, which we all decide are those metrics that we're gonna hold these managers accountable for. So, if they don't meet it, I think it's our responsibility to tell them they didn't meet it.
Commissioner Sanchez, and then I want to speak. Go ahead.
And I want to thank Commissioner Santos for kind of just always bringing us back to what's the point, right? So my personal view is that these 7 people are a reflection of us, and we are completely open to the public. We're elected by the public. We're accountable for their money. And so I find myself in a very awkward position where in reviewing Manager A, and we say Manager A has done a good job, and Manager A should get a $10,000 raise. Where I struggle with from day one is there's a point of view that says you can go in an open session and say Manager A gets a $10,000 raise, but you can't tell the public why Manager A got a $10,000 raise. And it puts the body in a position where people are speculating, oh, they did it for subjective reasons, they did it because it's so-and-so's favorite person, whereas particularly with this board, who I believe is very committed to transparency, saying that, Mr. Employee, one of the 7, didn't meet metrics, or, and being specific, or even at the worst case, everyone in the council's opinion, every one of the people we hire has this phrase, shall serve at its pleasure. That the employees we hire shall serve it as pleasure. So we can have a very formal review with a 7.3 and a 9.2, or we can simply say, you no longer meet our pleasure, whether we have a sophisticated reason or a less sophisticated reason, whether we, and that to me is why I always felt that it's better to be public because about them, because when it justifies a raise when we give them. In the particular case of this utility, we have 7 people who have not had a raise for 5 years despite outstanding performance. But if we're not able to talk about their evaluation and why we thought they've done a great job, and it's for these reasons we're going to give them whatever we choose to give them, then we lose an opportunity to be transparent to our voters, our ratepayers, that say, here's why we think so-and-so deserves a raise. And I guess I'm willing to say, if it works for the raise, and I think you've asked the right, what happens when it's not a raise? What happens when it's a discipline? Then I'd rather err on the side of full disclosure to the ratepayers as to why 7 people who know going in that when you work for us, it's a unique position. And one of the requirements could be, depending on how this other piece goes, that you allow the commission to release your review. Now, to me, in practice, if someone doesn't meet our pleasure, I've seen this, to me, we would meet in executive session, and so Mr. Cruz no longer meets our pleasure. Let's agree to terminate him, and we can go into open session and say we terminate him because he no longer meets our pleasure. We don't have to elaborate. It would be up to us as a body to decide how much detail on a dismissal you wish to give. But on an approval, I believe we have to let our ratepayers that put us in this seat know why we think these 7 people have done a good enough job on their behalf to justify a raise. And if that's the risk that we would take by requiring it in their contract, knowing that they still could say, I was forced, I was whatever, and they can defend themselves, it just doesn't make sense to me that as being accountable to our ratepayers, that we can't talk about why they deserved a raise, or worst case, why they were dismissed. And that's why I would prefer, I've always argued that in the case of R7, it's as a part of employment. I would want them to to waive their right to release their performance evaluations. I think in practice, we have paid our people very well, in fact, even higher than what we pay our employees on the Allen Searle rating. And that's sort of kind of a compensation for waiving your right. We're putting you in a tough job, but we want you to be accountable to us, and since we're accountable to the public, I have to justify to the public why I may have given you a raise or not. So that's the way I think about it.
Can I just clarify something? When it comes to the two general managers, there's no discussion there. The law is very clear. So let's put them to the side. Let's only refer to the 5, okay? The general managers are done. And the point I'd like to make is that for these 5, the law allows them privacy. That's what the law says. That Commissioner Mtiako said that's in our current rules. The executive session is outlined, and it does say they are allowed privacy. So therefore, they have a right to privacy. Let me just finish.
I will.
Yeah. Okay. They have a right to privacy. And what you're suggesting, I want to make sure I'm correct on this, is you're asking them to give up this right to privacy. And by extension, see, I would have a problem when you're doing the appointment, because listening to Commissioner Guthertz, if you say this is your best candidate, but he doesn't want, I'm talking CFO, not GM, CFO, lawyers, or the board secretary. If you're talking about your best candidate as CFO, but that candidate does not want to waive his right, does that mean you move on to the not-so-good candidate? That's what I heard
And I
Commissioner
think
Guthertz.
that's violating their rights. And it gives them an opening to sue us.
Well, not only that, but let me just say, you're going to get chased. And so therefore, what that does is, we're not doing our ratepayers a good job because we're going for the second or third best, because the second person may say, I don't want to give up my right. So that to me is part of what I heard Judy say that I kind of agree with. Now, there's one other thing, and I need the legal counsel. It's very hard to kind of determine if you did a contract and you said you required them for the contract. I mean, I can see where he's struggling because he doesn't know all the parameters, and to defend you, it would depend. But we have had contracts, employment contracts with people. One was called the Hauser decision, where the Attorney General actually put it in this contract that you serve at my pleasure. And that attorney challenged that contract. And that contract was thrown out. So I'm just saying there's no guarantee. There's no thing that says, well, you signed it. Hauser signed the contract. He said, I agree, I'm going to serve at your pleasure. Then he turned around and withdrew that when the Attorney General said, well, I have no longer pleasure with you. So I think it's kind of like hard to kind of put that in a scenario and say, well, Vince, tell us how we're going to, because you don't know, we don't know everything at this time. That's all I'm saying, okay? So I would argue and say, the way the law is written, the law specifically for the 5, not for the 2, but just for the 5, is specific. We quoted the law in our CC rules. It says they have a right to privacy. That's all I'm saying, okay? Commissioner Sanchez.
Thank you,
And then
Mr.
Commissioner Guthertz.
What about a suggestion? I have a suggestion.
Well, I said Commissioner Sanchez and then
Oh,
Commissioner
I'm sorry,
Guthertz.
I didn't.
No problem.
Go
Yeah,
ahead.
that's what I said. I said Commissioner Sanchez and then Commissioner
Thank
Guthertz.
you, Mr. Chairman. So, but I'm now reading the opinion stated today of our independent counsel. And his first sentence is, his thought, my thought, our counsel, is an employee can waive his right to privacy. So he believes the law allows for an employee to waive their right to privacy. Would I be reading that sentence correctly? Your next sentence is they can still do other things, but I would disagree with anyone that says that an employee cannot waive their right to privacy. Legal counsel has said they can waive their right to privacy. That doesn't mean the movie's over, but he says it's not illegal to require them to waive their right to privacy. So I would disagree with anyone saying it's against the law to make them waive their right to privacy, because our legal counsel says you can ask someone to waive their right to privacy. So I just wanted to make that point.
Okay,
And I also-
there's a
my second
complication
point is-
though.
Well, hold on, let me finish. Then my second point is I think we're confusing when we hire someone and after we hire someone when we evaluate someone. When we hire someone is a totally different activity, whether we're going to hire them or not, than once they are hired and we evaluate them periodically. And there is a debate, a healthy debate, for which we've asked counsel to join us, as to whether subsequent to hiring, can the evaluations of our 6 people, because we know the GM is required to be public,
Five
can the
people.
evaluate,
You said 7, so the 2 are out, the 2
Oh, well,
gentlemen, so
no,
5.
five, so but-
Okay, just want to make sure we're,
yes,
okay.
for the 5 that are not the GMs,
Yes.
the question is not whether they can waive their right to privacy, because counsel says they can waive their right to privacy. You can put it in the contract, and I'm just reading, and unless you're going to correct your own writing, my thought is an employee can waive his right to privacy. So outside counsel says you can waive it. You could put it in our contract, and they can sign it. His next sentence speaks to what happens after it's signed, that employee may still have the right to act, right?
Okay.
But he is not saying from the get-go, if you require it initially up front, that the employee cannot, that they can waive their right to privacy. He's just, if I'm reading his opinion right, he's describing 2 separate steps. One is, can he waive his rights to privacy? Sure. He then says, after he's waived his, in fact, it would only occur after he waived his right to privacy, he can then change his mind. You're saying that would be, the question is whether he can reassert it. That's a separate legal question. But that is separate from whether initially, correct me if I'm wrong, your legal review says an employee can waive their right to privacy, correct?
Okay. I was given this task, I think, pretty recently, so that's why I said my thought is that you can do it. I still think you can waive your rights, and that shouldn't be, you can waive all kinds of things. Then the question is it going to be enforceable? And that's where,
The issues.
yeah, I mean, you can put that in the contract. What I would do in the contract is you have to put another provision in there saying that if any portion of this contract is found to be unenforceable, it doesn't invalidate the remaining portion
Sure.
of it. So you're gonna have to put that in there with the
But if you put
understanding.
those 2 in, they can waive their right,
And then
correct?
the question is, if it gets to litigation, then the question is whether it's gonna be validated.
Absolutely, but nothing prevents us initially, if we put in these 2 clauses that you're recommending, from having, if the CCU wants to put in a contract for its 7 people, all right, that it can require 5 of them to waive their right to privacy as a condition of employment. And whatever happens after that is
First of all,
whatever happens. But it's not illegal to correct me if I'm wrong, it is not illegal to require that as a condition of employment, that an employee of the CCU waives their privacy.
What I'm saying is
I
you
don't
can
think I
put
would
that
say
in.
Wait, let me add, well, you can
Go
disagree
ahead.
with him, but I want to hear what he says.
He didn't say that.
Well,
but
what
go
he
ahead.
said, my thought is an employee can waive his right to
Okay.
privacy.
Go ahead.
Explain that thought.
So you can put that in the contract.
You can put it in.
Now, the question is whether it's going to be enforceable, and that's what I'm saying, is if you put it in the contract and everybody agrees, one of the things you can say in defense of the contract is that there was an agreement and there was an adequate
Therefore, it's
contract.
enforceable at that argument.
And then you go to the other side and say, well, when I sign this thing, and then you say all the various reasons why it shouldn't be enforceable. So what I'm saying is, I wouldn't, I mean, you could put it in the contract, I'm not, and I can't say whether it's going to be valid or not.
keeping
You
track.
can put it in the contract, sure, you can put
Okay,
it,
put in the contract.
yeah.
Any contract has a risk.
Okay, so
Thank you. Thank you.
Commissioner Guthertz.
First of all, you're in fact wanting to make this a condition of employment. Yes, isn't that true?
Yes, yes.
That unless they agree to this, you're not gonna hire them.
Yes. For
That's,
the reasons I outlined when I was.
yeah, okay, whatever,
Commissioner
whatever.
Sanchez's question.
That's what's wrong with this, because it is not consistent with what the law allows.
Are you saying?
The law,
said-
we're.
He just said,
Excuse
his
me,
rule
I'm
of the
talking
law.
about the privacy rights
Let her
of
speak,
individuals.
Simon.
So what law are you
Let
citing?
her
It's in the Guam rules and regulations. It's in the laws of Guam. That employees have a right to privacy when it comes to personnel matters. That's the controller here. Now, if you say, well, we want you to waive that, then we'll hire you. You're making it a condition of employment.
He says they can waive it.
That is challengeable.
Anything's challenging.
Yeah, wait a minute. As a member of the commission, I don't want to start off on the wrong foot when I'm going to support the hiring of somebody by making this a condition of employment.
So how do you justify giving them pay raises? If you can't tell
No,
the
we're
public
talking
why?
about I'm talking about hiring, right?
Well, that was my first point. We seem to be talking about two separate subjects.
Well, we
It's the
start
hiring.
from the beginning, the
Well, then
hiring,
just talk about the hiring, and then let's talk about post-hiring, which was my point. After you hire them, can you evaluate them and made it public? That's what we're
Personally,
debating.
I don't think you can do it that way for either part, okay? Because the law guarantees the right to privacy on personnel matters.
Except for GMs.
Except for GMs. However, I think there's a way to do this, and that's to ask the legislature to amend the law. For the same reasons we're discussing here, we explain to the senators we would like to be able to treat employees that we're responsible for the same way that we're allowed to treat the hiring of our general manager, both GPA and GWA. That would be the cleanest way to do this. Because I foresee getting into trouble if we insist on doing this. I think it will backfire on us. So that's my opinion. Thank you.
Okay. You're talking about making this a condition of employment. However, my concern, this is really moot right now for the 5 people we have, because we have 5 current employees. Could you go to a current employee and say, if you're going to stay employed, you have to sign this? Well, I mean, no, I mean, I'm just saying. Could you go and say, my cause for terminating you is strictly that you would not sign this piece of paper?
I don't think that would work. You can terminate people basically.
For
anything
cause?
you want,
Okay.
but you can't terminate them for improper purposes. And this might be considered an improper purpose because you're saying.
We want you to waive your privacy rights.
Okay, wait. We asking him to let him talk. Okay. Commissioner Santos, right after Commissioner Menchaca. No, thank you for answering, because I think that's. Yeah, his answer, just for the record, you want to restate it, or do you want me to?
No, I heard it.
No, I just want to make
wondering
sure.
if you're satisfied with the answer.
Yeah, I think
Okay.
I got the answer I wanted.
So, just my quick, there's 4 former senators in this office here, right? Just think about what drove the legislature to enact 5 GCA 43202.
It was Senator Respicio's bill in his first term, whenever that was.
Yes. But
It's been around
basically,
since the 90s, but it was never codified till recently, that's why no one paid it.
But-
Well,
but
I can
I'll
say
read
that,
the-
DOE paid attention to it. So
DOE has always been paying attention to
Yeah,
it, and in fact, you have the most experience because you were on the DOE board.
But we didn't, I can assure you that we did not make a condition of John Fernandez's contract.
It's not a condition.
To be, and I'll explain why, right? Because his KPIs is law. He's got 14 points that John Fernandez has to abide. Okay?
You can't change them.
Our GPA, GWA general manager does not have a 14-point law to, keep the power on, keep the water loose.
But now he has a law that says whatever our metrics are, it must be released to the public.
Again, can I just?
Go ahead,
Real
Commissioner.
quick point,
Something.
okay?
You have the floor.
We're gonna go round and round. I can tell you that right now. You don't have the votes to pass this. No. So I'm not.
Well, we know that now after you said that. We were trying to convince you.
Again,
Okay.
I know where Simon is coming from because we got our hands spanked really bad about employees that deserve a pay raise. I'm 100% for giving every single manager in this operation we oversee a raise that they deserve. Because they deserve it. I'm willing with their approval. Okay, I'm not gonna agree to the removing your right to privacy, but I will ask them this. When we go out in public, back into the executive and into open session, will you allow each and every one of us to stand up and justify your pay raise for? Okay? I think that's
I like that.
not maybe the best approach to do
I
it,
like that.
but why not? We've done it on the floor when we support something that we approve of.
I'm still in queue. I just yielded your
No,
time,
but
my time to you.
I know what it's like to go down and ask the legislature to change something. I think in our opinion, it's the right approach for us, because it's, to me, it's the right way to fix this. And I've always been of the opinion that we're way ahead of everybody else in trying to fix what's right for our employees, but more so our Guam employees and everybody else that deserve this. So I like that. Let's put our house in order first, and then say, can you fix this for us? I'm down for agreeing on, but I just feel that the law needs to be fixed too.
Commissioner Sanchez, my apologies.
So with-
Commissioner Sanchez, my
sorry.
apologies. Just a minute.
I'm sorry. Okay,
No, I was trying to tell you, my apologies. Commissioner Jaffe still has the floor.
When you get-
So I just
wait.
wanted Commissioner Santos to continue on his train of thought, but going back to my previous question as former senators, what do you think the intent of those senators on the floor that day was meant, what do you think their intent was in order to pass this law, right? And I'll read it to you. The governing boards of all agencies, instrumentalities, or entities shall issue performance reviews of the chief executive selected for that agency 6 months after appointment of the said executive, and every 12 months thereafter that the chief executive is retained by the governing board. Each performance review shall document the chief executive's performance, accomplishments, and the respective governing board's reason for retaining this said chief executive. You know, it's real clear. Their intent was to let the public know how well or how poorly these people
For
were
the
doing.
agency head,
Yeah, right, but
no other position.
Yeah,
They
but-
didn't- They didn't think far ahead. They weren't thinking beyond the head of the agency.
I disagree with you. I think that they were thinking about those under the authority of the board. And for the most part, the authority of the board is just for that GM.
Well, at that time-
Our commission is in charge of the 7 individuals, right?
At
2 of
that
which
time,
are
that
general
passed.
managers. So the remaining 5, it's still under the board.
Yeah, but I don't
It's
think
under
we
the
had-
direct
I don't think we
employment
had
of the
the
board.
remaining 5 at that time,
I'm sorry?
when this passed.
Oh, no.
No, it was way before.
Yeah.
Vince knows.
Right, but still, the intent of the law was just to make sure that the public knew how well
The agency heads.
either okay. Either or.
That's-
I think you're missing the point. The
the law
point
is-
is
I know what
that,
you're saying.
yeah.
The laws.
They
Listen,
don't think
Commissioner.
that broadly, unfortunately.
Commissioners, all good discussion.
Yeah.
I think, unless you're going to say something different than you've said already, I like Commissioner Santos brings us back to the point. What do we as a body want to do? And there's a vote to be taken. And that's all I'm saying. Unless you're going to say something different.
We should do 2 things.
So
Okay, wait, let him talk.
Correction if I'm
Okay.
wrong, colleagues. I think we were ready to adopt the rules. There was just one section of the rules having to do with the evaluation and whether or not we can make public the evaluations of
The 5 people.
Of the 5.
At the time 7, it's now clear that of
2 are
5,
done.
that 2 are obviously required, and the other 5. So
So-
it seems to me we should go back when we get into the, I guess we're in the rule, we're in the
We're in the
work
discussion.
session for the rules.
Yeah,
right?
work session, so
I guess we
it's-
can go back to that section of the rules and debate the language that would reflect the decision of the body
Yeah.
and put
Or
put that to a
establish-
vote and put that in there.
Yeah, that's what I'm saying. So I like Commissioner Santos has brought us back to where we are. And so,
We need to go to the rules.
yeah, no.
Go to the section of the rules that
The
has
section of the rule
that
on
language, that
evaluation.
area, and
Yeah.
then someone needs to make a
Propose some
motion
language.
to change
To
the
propose-
language.
propose
or
some language.
Whatever the language is.
Yeah, okay,
And then we can discuss it one last time in the vote.
yeah, okay. So
Who else is on
that is,
the legislature?
that is,
Think about it.
I'm trying to remember what
Okay, I
page.
have an idea. Just
Okay,
came
yeah,
to me right here.
you go ahead, Judy. Hold on.
How old is the PUC at the time?
And then PUC doesn't hire anybody, but CCU, yeah, we were passing over. Anyway, it was a
Michael,
while
what
ago,
page would that
but
be on?
we have two good examples.
evaluation
You-
section?
You always implemented it,
14, that was
and
it.
we haven't.
Okay.
So whenever it existed, in practice, some have implemented it and some haven't.
And
Okay.
just for some clarification on Fernandez's evaluation, it's actually, it's public.
Yeah.
Yeah,
Exactly.
I mean.
That's our point, that's our point.
I mean, there's 14 folders
yeah,
that are put out there that say,
we-
why don't you doing this one?
We like that idea.
yeah. No, and
Two of us like
actually,
that idea.
and actually,
I'm just saying.
It's just whether it should apply to the other
yeah.
five, right?
No,
So
yeah,
that's the
and for the two general managers, it's crystal clear. There's no debate, and that's done.
Okay, I have an
It's all-
idea.
Okay, so.
So what
Judy?
page are we looking at?
Page 14
Performance evaluations, okay.
is the big one,
There's two different things.
Go ahead.
One is actually gonna be language for the rules regarding performance evaluations, other than the general managers. And the other action that should be in the motion would be to make an official request to the legislature to amend the law. That would be later.
That'd be later.
Yeah,
Let's
I'm
just stick
just
to
saying
the-
what my thinking is.
Sure.
Okay, so.
I don't have a problem with that, but
I would suggest that,
why don't you suggest,
Okay.
why don't you cite the law on the general managers first? So that the
Well,
evaluation
okay.
is clear. That,
okay,
Well, just propose a change to the language. Like, to me,
That's
you
what
just
I'm-
delete general managers.
well, no, I think, Commissioner Sanchez, I think it is good to be very clear. So
Yeah, we
I
have to
think.
be very clear. We have to
so
start with the general manager.
So I think you start this
Any
with regards
performance-
to the.
And then
No,
you
no.
just delete the other
Yeah, yeah,
offices.
yeah.
Right?
Any-
If I hear the spirit of the body correctly, other than the GM, the CFOs, the attorneys, and other staff
secretary.
directly hired shall not be required to have their,
No, but I have a.
so,
I have
so to me,
another
to
way
correct, to
say it.
fix it,
Yeah, I have an idea.
Well,
Can I
I'm-
share it with you?
I'm not gonna propose a
Okay.
motion. I'm not like Ben, propose a
This is
motion.
just
I'm
an
gonna vote against.
idea. Any performance evaluations of the general managers shall be performed in an open session, the CCU, and transcribed. Now, any performance evaluations of the chief financial officers, commission attorneys, or staff under the direct hiring authority of the CCU the CCU shall request from the chief financial officers, commission attorneys, or other staff or personnel directly hired by the commission to authorize the release of their performance evaluations during an open session of the commission in order to ensure transparency of all personnel actions by the commission.
Okay, wait.
Something along those
Wait,
lines.
Can we get that in writing? Because I think
Well,
you're about to make everything public.
yes, that makes
Which is
everything.
But
works for
with,
me.
with the
ready to vote.
permission, I said
wait.
here,
I second that. I
I
second.
said with the permission
Okay,
of the chief financial officers, commission attorneys,
On the motion.
wait.
or
You need a
other
second.
staff or personnel
We're not gonna, this is just to
directly
write it.
hired by the CCU.
She's making a motion in a second, and then we got to discuss it.
The performance
This is just a
evaluations
Working session.
of
We're-
said
we're
personnel.
Rewriting, rewriting.
Said
We're
personnel
going to adopt it in the
shall be
CCU
made
meeting.
public during an open
Okay.
session
This is
of the
just the right-
commission and transcribed. So in other words, you're saying, with their permission.
After the fact.
What do you mean after the fact?
After the evaluation has been completed, they would
Yeah,
give us their
they
permission.
would agree that we would
And
make
if-
it public.
The terrible one, they'd probably say no.
Well,
But hey,
I
I'm
think-
fine. I am
think
fine with the
until we get the law
compromise.
changed, if we get the law changed, we'll be good, but,
Okay.
No, it's an excellent compromise.
okay, thank you.
So,
For the GM,
okay,
And I think they
Okay.
will agree.
for the one that,
okay.
for the GM.
Can we have that, you want to write that up
Correct,
and
for
then
the
we'll print it
GMs.
out real
Correct,
quick so we can all look at it?
Well, that's the easy
Yeah, I
one,
think,
because
we can
they've
have them
opined
do
and
it,
we
but,
agree,
let's-
right? Or
you and I
we're bound by this,
wordsmith
right?
it right
It's the
now.
other, it's the other five.
So what I would say, leave the first part,
All the way up to.
wait, the performance
All the way up to
evaluation,
transcribed, right?
yeah, first we have to say the general managers.
Oh, you need me to take out everybody else?
Yeah.
Okay.
Any performance evaluations of the
the
general
general
managers,
How about,
directly
can-
hired by the CCU shall be performed in the open session of the
What
CCU and
legislature?
transcribed.
What
Judy, can I suggest that we just cite the law?
No, no, we want it clear so the public will know.
So 16 years ago, right?
Make
We're
it
in the
public.
35th?
Okay.
Okay,
Then,
2003.
so that's one
We can,
sentence.
With- then-
make it, we can say
That's how
in
long it's-
accordance
so
with
the CCU was already in-
43.
Well, that's what I thought.
yes,
CCU
okay,
was
then
already
any
in place.
performance evaluations of the general managers. So that would be the first phrase.
But the law,
Okay,
In
and then-
accordance
the law,
with.
we just didn't do what you did.
Let
We
me
should have
write
done
that
what
up.
you
In
did.
accordance with
But the GMs are easy.
BCA
It's clear.
4302.
Comma, any performance.
Hold on,
of-
hold on. Okay.
Who is governed?
No,
Got it?
separate sentence.
Okay, now we're on a new sentence,
Separate
right? As a condition of employment,
No,
No.
Okay.
No, it says, wait, first you had, in accordance with public law 5,
right after transcribed, yeah.
The performance evaluations of the general managers.
Okay, hold on. Does it should include the general manager?
No, we're just doing the general managers first. We want to separate them from the others.
I think
we-
that finishes it though.
Yes.
Just that one sentence takes care
Yeah,
of
that
it.
one sentence
Okay,
finishes it.
then,
Now talk about the rest.
all right,
Five.
then,
Separate sentence.
We're
Yes.
taking out as a condition of employment,
yeah, that's correct.
we're taking out general manager reference.
And now we're going to, the performance with the permission of the chief financial officers, commission attorneys, or other staff or personnel directly hired by the CCU
Mm-hmm.
in accordance with public law. Their performance evaluation shall be announced in open session of the CCU and transcribed and made public.
With their permission.
Yeah, I
It
said
says
that at the
Okay,
beginning of the
okay.
sentence.
I didn't catch
With
it.
the permission of the chief financial officers, commission attorneys, or other staff or personnel directly hired by the CCU, their initial performance evaluation.
Mhm.
What do you want to say? Their hiring?
No, they're just their
Okay,
performance.
their
event.
performance evaluation
It's only evaluation.
shall be performed in an open session of the CCU and transcribed and made public. Period.
Then the rest. So you want to write? Look at it.
Well, I'm going to read it. Okay, so now that section 2.1.2, performance evaluation now reads, any performance evaluation of the general manager directly hired by the CCU shall be performed in an open session of the CCU and transcribed in accordance with 5 GA 43202. Is that citation? Okay. And then with the permission of the chief financial officer, legal counsel, or other staff personnel directly hired by the CCU, their performance evaluation shall be performed in an open session of the CCU and transcribed and be made public.
Should we add be made
Does-
public
I
also
think
with the general managers?
I think by the nature of
You don't
open
need to
session
say
and
made
transcribed, yeah,
Okay.
I think it's pretty.
Okay, that's it.
You just add one word.
Okay.
Oh, written
Written
permission,
permission, yes,
okay, yeah,
written
that's a good idea, very good.
That amnesia.
Yes,
Okay.
I like that. Okay,
Amnesia.
So that would be for this, but our goal also, Mr. Chairman, is to make a request to
that's a
change the law.
separate issue, yeah.
Okay,
That's separate, we, you know, that. we
Okay.
can-
Is there any, Commissioner Sanchez?
Oh, do you raise your hand for something? I like that one.
Except for the GMs though.
That's very true.
I always envisioned
With their permission.
this is consistent with that.
So
That's what the board does.
But you wouldn't deliberate. An evaluation shall be performed in open session. You're deliberating in open session, right? I always envision, and maybe that's part of the, why there's a difference of opinion.
The
right?
evaluation
Yeah.
shall be released in open session, or shall
That,
be,
that's what
Yeah.
I mean, that's why, I guess, in this whole discussion,
Or a separate
I wasn't so worried,
evaluation
worried
shall be
about whether they required it or not, because I always felt the body would be, it's
Maybe a
easy, it's
summary
easy
of
to
the
just, it's
evaluation
easy.
shall be released in
Well,
open
that's,
session.
so my question is, in the proposed language, we're talking about doing the evaluations in public. I had never envisioned doing the actual evaluations in public. I always
Just
felt
to
you wanted the
release-
freedom as a body to discuss Mr. Employment.
So we report
But-
on the
But
evaluation.
once you've done an evaluation in executive, what do you do with that evaluation? You're either gonna change up, no change, change down, or dismiss. I think those are the only four options. You're either gonna give a raise, maintain their pay, cut their pay, or dismiss them. I can't think of any other thing you would do as a decision maker when it comes to an employee. Those are your four choices. You know, keep them and pay them up, down, the same, or get rid of them, right? So that's why I'm debating the language that we're proposing, is that we would actually evaluate. If you're gonna, put it this
I'm
way,
okay
if
with
you're gonna
that.
evaluate in public, you don't need their permission, it's in public.
Yes,
So I think you need to be careful about the
The
use of
language.
the word in
Yeah.
public. I always thought that you can deliberate in private, but when you come out, you must summarize your deliberation in order to justify the pay. It never, I agree with Commissioner Santos so completely that we got heavily criticized because we didn't justify pay adjustments to our people. And we sort of got hung up on this, well, because it has to be private or not to this day. And I always thought that you deliberate in private, but if you come out and say, ours, 5 plus 2, we now, does the law for the two GMs say you deliberate in public, or you just
yeah.
release their
It's
valuation?
everything is in public.
Okay, so for those two, you're deliberating in
Yeah,
public.
well, that's
So,
clear.
Right, now for the 5, do you wish to deliberate in public, or do you wish to deliberate
No.
in executive, but only announce the results of your deliberation in open, and any change in pay, which can only take effect in open? I always thought you would not, I didn't see us doing a public review.
Okay, so amend the language then.
It's sort of like this.
Okay.
when-
So,
Okay, that's
So I
fine.
just want to make sure that's the intent of the
Okay.
language.
I knew that was your intent.
with the permission of the employee, right?
It hasn't changed.
Okay.
Can we listen? Let's listen.
evaluation of the general managers directly hired by the CCU shall be performed in an open session of the CCU, transcribed and published in accordance to 5 GCA 43202. With the written permission of the chief financial officers, legal counsel, or other staff or personnel directly, the performance evaluation shall be disclosed in open session of the CCU, transcribed and published. Disclosed, yeah.
I'm okay with that.
I changed that word.
Proposed or presented.
So in other words, you're only going to discuss their evaluation
The
as
summary of
executive,
evaluation shall be
Okay.
presented.
and then you're going to disclose your findings.
Okay.
Whatever the nature of that
Summary
takes.
of evaluation
Okay.
shall be presented.
With their permission.
Or a report of the evaluation shall be presented.
Well, I mean, pick the words. I mean, I think they're very
That's
careful.
why
I mean, already we're being very precise.
Yeah.
Disclosure
Print it,
is in
that way we all
public,
look at it.
not discussion.
Please.
Correct.
Okay,
Report of the evaluations. might
I
be
put
better.
a report of the performance
Yeah,
evaluation.
I
Shall
think
be
that would be better.
shall be disclosed.
Yeah.
okay.
Or open.
So can I ask that you send that to Lou so that she could
Well,
put it?
can you at
because
least
I-
have a vote on it for the
No,
record?
no, no,
and then-
I
and
want
then
to
we can
read
vote
it
on
for, I'd like
want to read
to,
the
I'd like
top
to
one.
read it, if you don't mind.
And then we also want the
I'm-
attorney
And
to
the
look
proposed
at it.
amendment.
Yes.
Wait, attorney, do you have a comment on it?
Oh, just one little thing on, didn't hear any discussion on the assistant general manager.
They're not under our purview
No,
anymore.
no, for the AGMO, he's talking about the AGMO.
But there's still
No,
not,
no.
there's still none of, that we have no authority over the AGMO other than the,
Well, we do concur
We
with
do,
the
we
pay.
have to concur with the pay.
yeah, that's it.
Well, we-
No, but that happens in executive session, out in open session?
But it's
no.
not part of the, we don't do the evaluation.
No, no, the
Oh,
general
okay,
manager just presents
okay, you're right.
to us during the meeting.
Yeah,
Do not do
okay.
Yeah, not,
Okay.
we don't evaluate.
Yeah,
Point-
we either
point-
say yea or
point-
nay.
I want to make sure
Got
your
it.
point is taken. This specifically just deals with evaluations.
Correct, which the
Okay.
GM does.
Okay, but for clarity, let's be clear that when the GM from now on says, I want to give a raise to my AGMO, that GM has to come to us and explain to us. Now, open session, executive session, that's your pleasure. Yeah, no, I'm just saying, maybe we need to clarify that for, no,
Now
maybe,
you're going to do some evaluations and open
no,
and some.
Well, these are his recommendations.
okay, so, wait, okay, so, I'm just saying.
That's what he did
That's
last
why
time.
What if we
He did it in
disagree?
open session.
Okay, commissioners, that's why I'm bringing it up, because it's kind of like out there in left field. And I'm just
have
saying,
another provision.
do we want to put it in here, or can we just establish a policy later on that?
No, put a section
The
B.
policy already, you guys already determined the policy, right? It's other than those two GMs, you can't do it in open session. That's what you guys are, so the AGMO falls under that. So it's an executive session, and when we
As long
come-
as you're
but
sure.
when we're
But it's got to be
discussing,
disclosed.
how am I not sure? That's exactly what you guys have
No,
been
No,
arguing
no,
the
no.
whole time.
No, I
Then
know, but.
Then after we
The law doesn't
accept
say
his,
AGMO.
Okay.
if we accept his
GM.
recommendation, then we can say we concur with. during
Okay,
this
okay,
regular
And that
session.
has
just
to
print it out,
happen
so we can
in-
read it. Okay, so let's print it out, just so we can all read it. And if, here, commissioners, here's my thought, let's print it out so that I can read it.
I'm only gonna have her print that one section.
Just that one
okay?
section, just send her that one page if you want. Or just that one section if you can. No, okay, 5-minute recess. Just 5 minutes. I need that. this working session. Motion to adjourn, second? To adjourn this working session. All those in favor signify by saying aye. But the meeting, this working session is adjourned. Okay.